Welcome back to the High Court Report. Today we tackle a case that could fundamentally reshape how the federal government operates for the next century. Trump versus Slaughter challenges the very foundation of independent agencies. When I say fundamentally reshape, I mean this case will determine whether the president can fire the heads of 24 independent agencies at will, agencies that control your mortgage rates, workplace safety, food safety, and investment protections.
I can't wait to talk about this case. But before we get going, let's briefly run through 3 housekeeping matters. First, coming up Black Friday, November 28th, our first ever High Court Report mailbag episode. I'm really excited about the chance to interact with you, the audience. This term delivered blockbuster after blockbuster. You've got questions, you've got theories about how these cases connect. You want to know what I'm watching for in oral arguments, or which decisions could ripple through your practice area. Send your questions and comments by Monday, November 24th. Email us at scotus.cases.pod@gmail.com or message us on LinkedIn at the High Court Report. I'll read your message on air and dive deep into the answers. What's your take on this term's biggest constitutional battles?
I can't wait for that. Send in your submissions.
Second, let's quickly survey the Supreme Court's packed December calendar. The court hears arguments the first 2 weeks of December before breaking until January. And they've loaded these 2 weeks with blockbuster cases.
We count 2 mega cases and 2 other especially significant ones. The mega cases, Trump versus Slaughter on December 8th, the case we're covering today that could reshape the entire administrative state. Then NRSC versus FEC on December 9th, which challenges core campaign finance regulations and could transform how political parties fund Senate races.
The 2 other major cases, Cox versus Sony on December 1st, a billion-dollar battle over whether internet service providers face liability when their subscribers commit copyright infringement. This could fundamentally change how ISPs police their networks and affect every American's internet access.
And Olivier versus City of Brandon on December 3rd, which confronts a sharp-circuit split about whether citizens can challenge unconstitutional laws in federal court after paying fines rather than appealing their convictions. This affects every American's ability to contest constitutional violations.
The December calendar also includes First Choice versus Platkin on December 2nd, a First Amendment fight over state subpoenas targeting nonprofit donor records, plus 2 cases on December 10th, Ham versus Smith, testing Eighth Amendment protections for intellectually disabled death row inmates, and FS Credit versus Saba Capital, a high-stakes investment industry dispute.
So December delivers constitutional clashes across presidential power, campaign finance, copyright law, religious liberty, capital punishment, and financial regulation. But Trump versus Slaughter stands out as the case most likely to transform government structure for generations.
Third, I want to sketch out your Supreme Court content roadmap for the next 2 weeks, because we're delivering a content feast that rivals your Thanksgiving spread. This week, we complete our remaining December episode previews, giving you the full picture of these hugely important cases before oral arguments begin.
But next week, Thanksgiving week, we transform into your Supreme Court binge companion. Whether you're navigating airport delays, enduring long car rides to family gatherings, or hiding from relatives in the guest room, will be your constant source of high-quality legal analysis.
Monday drops our deep dive into October's most significant cases and their broader implications. Tuesday delivers our comprehensive November cases roundup, connecting the dots between recent decisions and emerging constitutional trends.
Wednesday gets personal. I pull back the curtain on how the High Court Report actually operates. You'll discover our research process, how we prepare for complex constitutional analysis, and the behind-the-scenes work that makes this podcast possible. I'm genuinely excited to share these insights with our community.
Thursday, we pause for Thanksgiving, because even constitutional nerds need turkey time. But Friday delivers our mailbag episode plus a mega December term preview, synthesizing everything you need to understand before arguments begin December 1st.
Here's your action item. Share these episodes with family and friends during holiday gatherings. Constitutional law sparks fascinating dinner conversations, and we want to arm you with compelling talking points that elevate your Thanksgiving discussions beyond politics into actual legal analysis.
Transform your holiday break into a Supreme Court education opportunity. Your relatives will thank you for the intellectual stimulation, and you'll become the family's go-to legal expert. That's it for housekeeping. Let's move on to the heart of today's episode, the next frontier in the constitutional battle over presidential power. Let me tell you exactly what you'll know by the end of this episode that you don't know now. You'll understand why this case represents the biggest challenge to government structure since the New Deal. You'll know which specific agencies face elimination or radical transformation. And you'll learn the 3 concrete actions you should take before oral arguments next week.
Here's what hangs in the balance. President Trump removes FTC Commissioner Rebecca Slaughter without cause, just sends her an email saying, "Your service conflicts with my priorities." No inefficiency, no misconduct, just political disagreement. But here's the critical detail most coverage misses. This removal affects agencies that directly control $47 trillion in economic activity. The Federal Reserve sets interest rates for your mortgage. The FTC approves mergers that determine if Amazon can buy your local grocery chain. The SEC decides which investment risks companies must disclose to you.
And Commissioner Slaughter wins in lower courts. They declare her removal unlawful. But now the Supreme Court takes the case, and constitutional scholars predict this could trigger the most dramatic restructuring of federal power since 1935.
What you need to understand: if the president wins, every independent agency becomes an at-will political appointment. That means each new president could fire and replace all commissioners, destroying the stability these agencies provide to markets and regulations.
The court confronts this precise question: whether Congress can require the president to show cause, like inefficiency or misconduct, before removing commissioners of independent agencies, or whether Article 2 grants the president absolute removal power.
Let me read the constitutional text everyone's fighting over. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. The Appointments Clause in Article 2 specifies how officers of the United States must be appointed, dividing all officers into 2 classes. Principal officers must be appointed by the President with the advice and consent of the Senate. Inferior officers, likewise, may be appointed by presidential nomination and Senate confirmation, but Congress may also, by law, vest their appointment in the President alone, in the courts of law, or in the heads of departments. And Section 3, the President shall take care that the laws be faithfully executed.
Let's decode the Constitution's hiring rules, because understanding who gets hired, how, becomes crucial to understanding who gets fired when. Article 2 creates 2 officer classes. Principal officers require presidential nomination plus Senate confirmation, while inferior officers can be appointed by the president alone, courts, or department heads. Congress chooses which method.
Notice what the Constitution doesn't say. It doesn't explicitly grant removal power. The president's authority flows from implication. If all executive power belongs to the president and he must ensure faithful execution of laws, then arguably he must control all executive officers.
But Commissioner Slaughter points to another provision that complicates this reading. Article 2. Section 2 says the president may require the opinion in writing of the principal officer in each of the executive departments. Her argument: if the Constitution specifies this minor way the president can command officers, maybe it doesn't grant unlimited removal authority.
That's sophisticated constitutional interpretation. The explicit mention of specific presidential powers might limit, rather than expand, implied powers over removal.
Here's the story that leads to this constitutional showdown. In 1914, Congress creates the Federal Trade Commission as a 5-member body with 7-year staggered terms. Commissioners can only face removal for inefficiency, neglect of duty, or malfeasance in office.
Fast forward to 2018. President Trump nominates Rebecca Slaughter as FTC Commissioner. Senate confirms her unanimously. In 2024, President Biden renominates her for a second term. Senate again confirms her unanimously, meaning she received bipartisan support from both Republican and Democratic senators. Her term runs until September 2029, but in March 2025, President Trump decides she's inconsistent with my administration's priorities and fires her via email. No cause, no hearing, no due process. Commissioner Slaughter sues in D.C. federal court. She argues the removal violates federal law because the president provided no statutory cause. The district court agrees, grants summary judgment, declares the removal unlawful, and issues an injunction preventing interference with her duties.
The administration appeals and seeks emergency stays, but courts keep ruling against them. That's when the Supreme Court grants certiorari to resolve this fundamental question about government structure. And here's the detail that makes this case explosive. President Trump attempts similar removals across multiple agencies simultaneously. The NLRB, Merit Systems Protection Board, Consumer Product Safety Commission courts issue injunctions everywhere, creating a constitutional crisis. We covered these episodes over the summer.
Let's move to the key arguments, starting with the applicant, President Trump. First, he argues Article 2 grants conclusive and preclusive power to remove all executive officers. The vesting clause places all executive power in the president alone, not shared with Congress. The president grounds this in the Decision of 1789, when the first Congress debated executive departments. James Madison argued that the Constitution grants removal power that Congress cannot diminish or modify. The president calls this contemporaneous and weighty evidence from framers themselves.
Second, the president targets Humphrey's executor directly. That 1935 case upheld FTC removal protections, based on the theory that the FTC exercised no part of executive power, that it was quasi-legislative and quasi-judicial. But today's FTC operates completely differently. It files civil lawsuits seeking monetary penalties. It promulgates substantive rules with force of law. Its orders become final without judicial approval. The president argues these are quintessentially executive powers that the 1935 court never contemplated.
Third, on stare decisis, the president argues Humphrey's executor has become a doctrinal dinosaur. 4 recent cases, Free Enterprise Fund, Saylor Law, Collins, and Trump v. United States, have all confined Humphrey's executor without overruling it. The president says the court should finish the job.
Commissioner Slaughter makes equally sophisticated arguments. First, she claims historical tradition supports multi-member independent agencies. The first Congress itself created agencies with some independence: the Patent Office, the Mint, the Bank of the United States.
She emphasizes more than 2 centuries into an unbroken congressional practice of creating multi-member agencies. Presidents of both parties have signed legislation creating dozens of independent agencies and commissioned thousands of protected appointees. Second, she argues multi-member structure advances separation of powers and individual liberty. Before a multi-member agency can restrict someone's property or business, a majority of commissioners must agree. This deliberative process protects against arbitrary decision-making.
She quotes Judge Kavanaugh. A multi-member agency structure helps prevent arbitrary decision-making and abuse of power, and thus protects individual liberty. The built-in monitoring system creates dissents that alert Congress when agencies overstep.
Third, on constitutional text, she argues the Constitution doesn't require absolute removal power. The Take Care Clause doesn't help the president because it refutes the idea that the president should be a lawmaker. If Congress reasonably requires cause for removal, the president can fulfill his duty by following those procedures.
Oral arguments happen Monday, December 8th. Here's what to watch for that will signal how the court might rule.
First, listen for how justices handle the Federal Reserve exception. The president concedes the Fed might be different due to its unique history. But if history can create one exception, why not preserve the entire historical tradition of independent agencies?
Second, Watch for questions about practical consequences. If the court sides with the president, what happens to pending enforcement actions? Current regulations? Industries that planned around agency stability?
Justice Kagan will likely focus on reliance interests, the doctrine that courts shouldn't overturn precedents that people have relied on for decades. She's been the court's strongest defender of stare decisis recently.
And Chief Justice Roberts will probably ask about regulatory predictability. He's shown interest in administrative law questions that affect business planning and economic stability. He'll also key in on the differences between the agency functions in Humphrey's executor versus the agency actions here. We should remember two additional points. The Supreme Court already found this summer via the emergency docket that independent agency heads exercise a range of executive decision-making. In these rulings, the justices may have already made their decisions on this case.
Next point. Key in on the second question presented, whether trial courts can reinstall wrongly fired independent agency heads. This question only becomes at issue if the court decides that President Trump wrongly fired Ms. Slaughter. The conservative justices may believe that judges lack this authority.
This case affects far more than administrative lawyers. If you work in any regulated industry, banking, securities, labor relations, consumer products, telecommunications, this decision reshapes your operational environment.
Independent agencies provide stability that markets depend on. Interest rates don't fluctuate wildly with elections. Antitrust enforcement follows consistent principles across administrations. Consumer protection rules remain predictable. But if commissioners serve at presidential pleasure, that stability vanishes. Each new president could install commissioners who reverse previous policies immediately. The regulatory whiplash could destabilize entire economic sectors.
Think about it practically. Would you invest in a long-term project if environmental regulations could reverse completely every 4 years? Would you plan a merger if antitrust enforcement changed radically with each election? The constitutional implications extend beyond administrative agencies. This case asks fundamental questions about separation of powers in the modern state.
This echoes founding-era debates about independent judiciary. The Constitution grants judges life tenure precisely to insulate them from political pressure. The question is whether similar logic applies to administrative agencies with specialized expertise. The Supreme Court's December calendar creates unique urgency. Oral arguments December 8th, with a decision by June or sooner, but agencies make dozens of major decisions monthly that could face challenges. And here's something that amplifies the urgency. The court hears this case less than 2 months before the court hears Trump versus Cook, which involves President Trump's attempt to remove a Federal Reserve Board member for cause. So, the justices know their ruling in Slaughter directly shapes how they'll analyze the Fed case. That's crucial context. The president conceded the Federal Reserve might warrant special treatment due to its unique history. But if the court sides with the president in Slaughter and establishes absolute removal power, that concession becomes meaningless. The Cook case could force the court to apply whatever principle they establish here. Exactly. The justices understand they're not just deciding Commissioner Slaughter's fate, they're creating the constitutional framework that governs both traditional independent agencies and the Federal Reserve System. The proximity of these cases means the court can't punt on the fundamental question.
So why should Trump versus Slaughter matter to you personally? Because this case determines whether the agencies that regulate your daily life, food safety, workplace protection, investment fraud, operate as expert bodies making evidence-based decisions or as political arms changing direction with each election. For legal practitioners, this represents potentially the biggest shift in administrative law since the Administrative Procedure Act. Your practice strategies, client counseling, and regulatory predictions all depend on how the court rules.
For business leaders, this affects every long-term planning decision you make. Regulatory stability enables investment, innovation, and growth. Regulatory chaos creates uncertainty that stifles economic activity.
And for citizens, this shapes whether government agencies serve expertise and evidence or partisan politics and presidential preferences. The administrative state touches every aspect of modern life, From the safety of your medicine to the fairness of your workplace to the security of your investments.
We'll host oral arguments and provide analysis afterwards. Follow us here and on LinkedIn to get a high-quality breakdown.
After the decision drops in June, we'll break down exactly what changes, which agencies face immediate impact, and what practitioners and businesses should do immediately.
Thanks for listening to the High Court Report. Please follow, rate, and share the podcast. And connect with us on LinkedIn at the High Court Report for ongoing coverage of this transformational case.
In our next episode, we cover Oliver versus City of Brandon, a case that must answer whether Supreme Court precedent prevents people from using civil rights lawsuits to get future protection when they've already been punished under the same law they're challenging, and whether Supreme Court precedent bars Section 1983 claims by plaintiffs even where they never had access to federal habeas relief. We'll break it all down for you.
Talk to you soon.